Our guest today, as I said, is Kabir Duggal. I know I cannot do him justice by introducing him fully. He has an impressive bio. And one of the things that is not included in the bio, and usually that it's not included in bios in general, is talking about someone's personality. So I will take this opportunity and introduce Kabir in my own way and say that Kabir is a very kind person. He's very responsive and he's very supportive. He's involved in so many initiatives, and not only with the name, but he's actually very active and trying to put in the effort for what he stands for. I'll put in the chat the link to his official bio and his professional achievements, and you can read there and be inspired by so many things that he's been doing. I'm going to give the floor to Kabir, who's going to have a short presentation about communication with clients. Thank you for being here with us today, Kabir.
Thank you so much. Really delighted to be here. And let me just begin by commending our organizers. They're three amazing lawyers. All three happen to be women, so yay for representation. But when I was approached by these three amazing colleagues to do this presentation, my immediate thought was, we spend so much time thinking about the law that we forget the practice involves so much more than just the law. In fact, most of the clients assume you have some level of competence. That is assumed. They assume you know to read, write, present a case. It's really soft skills that make you stand out as somebody capable, as somebody good. So I really want to commend the organizers on this awesome program. Our topic for today, and this is envisioned as a interactive session. So keep the chat active. We're doing a 2020 with that in mind, that everyone can share experiences. That's how we learn, right? Our theme for today is communicating with clients. And we're going to begin with something that I think all of us would agree. Any soft skill, the most effective way to present that is to be yourself. That is, you have a unique style that works for Mihaela, which may be different from Svetlana, which may be different from Ilka, but it is a true representation of you. Now, people who know me know I tend to be a little more animated. I tend to use my hands a lot. I tend to be loud. That is me. It works for me, when people tell me, don't put your hands underneath. That's not natural. So the point we begin with is you will need to discover your style. You will need to discover what works for you and try to do that. Having said that, there are best practices. And we're going to walk you through the top 5 best practices, see what makes sense for you. These are time-tested rules, so we'll just try to thumb through some of them. We'll share some war anecdotes, right? The war stories, and then we can open it up for question and answers. Okay. I think this is the most important tip. Tip number 1, communicate clearly with your client and establish expectations, right? Now, this is when Mihaela approaches Kabir. I'm selling my legal services. Remember, we are service providers. You want to tell Mihaela exactly what she can expect. And here are the 2 relevant points. Don't overpromise. Remember, we are a profession in addition to being a service that we're providing. And it is when Mihaela approaches me, I know Mihaela can go to Ilka or Svetlana. And this is the risk we have. You tell Mihaela what she wants to hear without telling her the risks. Don't do that. Now, we are often told, under promise and overperform. Don't do that. I mean, the whole idea is for you to give Mihaela the best analysis of the case, the best analysis of the cost. Remember, we bill often by the hour, and this can become a nightmare if the rules have not been established clearly. Now, for most of us in arbitration, we love the alphabet soup, right? ICC, LCIA, ICSID, UNCITRAL, right? We have all these jargons. These are natural for us. Words like functus officio, competence, they mean something that is apparent to most of us. That may not always be the case for your client. And key point, simplify, explain, explain the process clearly. Mihaela should never find herself in a situation where she's caught off guard. My gosh, what is this bill? My gosh, what just happened? And again, remember, we are in an international practice. If Mihaela comes from a country where cross-examination doesn't happen, where document production doesn't happen, you need to explain what the process will look like. So tip number one, something we know, but something we tend to overlook when we approach our practice like a business. Okay? Point number two, you do this. See, tip one is talking about setting the stage. You're meeting the client, you're explaining the rules of the claim, you're establishing expectations. Tip number two tells us keep Mihaela posted at periodic intervals. It shouldn't be Mihaela hears from me when I need the case. Then Mihaela hears from me when the bill is sent to her. Then Mihaela hears 1 week before the hearing. Don't do that. Now, figure out what makes sense. People often say, establish, if the case warrants it, a point of contact. Tell Mihaela, Ilka is going to be the point of contact. If you have any questions, approach her. And then consider things like weekly or bi-weekly updates, right? Just checking in. Here's what's happened. Don't worry if nothing has happened. Sometimes our cases go through ups and downs. And just let them know, look, nothing's happening right now. We assume after this phase, we will be busy again. But just keep Mihaela abreast of what is happening. Share important updates on the law. We had a lot of people from London. An interesting decision from the London Commercial Court, the London Supreme Court. Just Mihaela, just wanted to let you know an interesting discussion, a decision has come out. Put a 3-line summary. Just thought it may be interesting to you. Now, Mihaela sends me an email. I'm traveling. I'm busy. I have life. I have family. I can't get to Mihaela's email ASAP. I think the courteous thing to do is just tell Mihaela, we're in receipt of your email. I'll get back to you 48 hours, 3 days. Set the expectation so Mihaela doesn't feel pissed off, doesn't feel abandoned, right? If Mihaela is in a company, a big company, and they require, I think in the UK it's CPD, it's CLE for us on the other side of the pond, or just a capacity building session. When we do investor state, you have government representatives. Consider doing partnership, do capacity building. We will circle back this, but try to see where you can add value and where you can add value which doesn't necessarily have a dollar, a pound, a euro attached to it. And then important, keep Mihaela at all stages aware of what is best. This is the best outcome. What is the likely outcome? But also tell her, look, this is one of the things in arbitration. Sometimes things just go completely different from what you envision. Now, realistically presented, look, our assessment is this. We believe best case this may happen, but we just want you to know this is a small risk, but this risk exists. Just again, so Mihaela isn't taken by surprise. The worst thing you can do is take somebody by surprise, either on the case or on the billing. The billing sometimes, especially if you have the billable hour model, will catch people in ways that they're not just ready for. Okay. Now, the third tip. Mihaela has hired Kabir because Mihaela trusts Kabir. And it's my job to be an empathetic, uh, empathetic advisor to Mihaela, to hear her actively, to try to advise her the best I can, and to be there to help her through what may be a very difficult moment in her life. For me, it is a case. For Mihaela, it may be her life. It may be, a decision for which she can be accountable. There may be a lot at stake. Now, I just add a slight caveat here. Listen to what Mihaela tells you, but this is where the trust but verify, especially when you're talking to Mihaela to prepare the statement of facts or a witness statement. Hear what she's saying, but just make sure you are doing a due diligence on your part. Because very often clients will tell you, and this is, any litigator, any arbitrator will tell you this. You're going to be told, this is exactly what happened. This is exactly what the document tells you. When you look at the document, it doesn't quite tell you something that you are being told the document tells you. Now, this is important. When you are in front of the tribunal, you need to make sure you are communicating exactly the fact to the tribunal. Mihaela, did you want to add something?
Yes, I wanted to add a question. How do
Yes,
you
please.
bring that to the client when they say something that is contradicted by a document? How you do it in a, let's say, a sensitive manner without annoying the client?
No, correct. Look, how do you handle clients is always tricky. Now, if the client seems receptive, you may want to just put it in a more positive manner. Look, I understand this perspective. Look, the documents tell us this. I think we are credibly going to be able to argue this, and then try to explain to them the risk. If you say this, you may be cross-examined on this, and if you cannot prove it, it's going to be embarrassing for you, but the credibility is destroyed, right? What is the single thing that we want to do in the case? We want persuasion and building credibility, right? Once that is lost, if I can't trust you on this, can I trust you on anything else? So maybe go gently, never tell them you're stupid, never. And there is a risk for that. So, you have to probably know your client and know what may work effectively. But at the end of the day, I think we are professionals. We should never say anything that we cannot defend. I think this is important. I will just share this story, Mihaela, because I think it brought it out. This was my second month in practice many years ago. An opposing counsel, we were representing Venezuela. Opposing counsel brought a challenge that the client told them they found in a blog. I know the client told them because opposing counsel is a friend, and she told me, we were told you have to file this. And they tell us Venezuela and Bolivia are going to become a new country, Bolizuela. They tell us what the currency is. They put a blog post that talks about this imminent merger. And the argument being made is you need to count the number of times Venezuela has appointed Venezuela's arbitrator and Bolivia. It was a French professor, and the number was like 20 times. But the argument really was Venezuela, Bolivia, they filed this within 24 hours. The blog at the end said, for further details on this merger, click here. Mihaela, I kid you not on this. I was 27. I clicked on that link and this popped up. This was put like in $1 billion case as evidence. And I just point this out because this happens. Sometimes clients are putting pressure on you. Do this, do this, do this, do this now. You feel, you feel pressured to do it. they did ultimately lose the case. Now, I
I
don't
would
know.
like to
Yeah,
I would
yeah.
like to see the face of the tribunal when opening that link. I'm
You
not
know,
sure if they were very happy to see that.
Mihaela, just to be honest, we thought the tribunal would be a lot more outraged. To be fair, the tribunal kept a neutral face. The
Maybe they are the professional poker players,
exactly.
they're accustomed to this.
Yeah, claimants did lose. They ultimately lost the challenge and they lost the case. Now, I can't establish a correlation, but credibility is everything. Once your credibility is lost, it's lost. And this is something you need to be very mindful when you're dealing with a client, because clients will often tell you, no, we want you to make this argument. We need you to say this. And you really have to make an assessment of whether this is good for the overall strategy or not. Be an empathetic ear, be an empathetic advisor, but also act in the client's best interest, even if they don't know what is best for them. If Mihaela could do it herself, she wouldn't come to Kabir. Let me just take this point because I think this is very important. We're in an international practice and we need to be culturally aware and sensitive. Now, this has a couple of things. If you are coming to the United States, it's a very open culture. It's a very in-your-face culture. It's a fairly aggressive culture. If you compare the US to the UK, both common law countries, I jokingly often say they're all essentially the same country. This offends most people, but they're very similar. But if you look at our litigation styles, our arbitration styles, they're completely different. And this is important when you're dealing with people from different cultures, from different backgrounds. Do they have the same shared expectation? A partner from Baker McKenzie told me this story. He was dealing with a Brazilian client, and he told the Brazilian client, take care of the documents for the document production phase, right? Pretty standard in most cases. We're going to go through a phase. You do the red phone schedules. Honestly, the most annoying part of our profession, but got to do it, right? You're making your red phone schedules. Now, in most of Latin American, just to be honest, in most civil law countries, document production is not a thing. When this partner went to Sao Paulo, he saw a big shredder and the client was shredding documents. And he asked them, what are you doing? And they tell him, you told us to take care of the documents. And they understood it to be take care, wink, wink of the documents. Right? Now, this is important because it just tells you people may not have the same understanding. People may not have the same understanding of concepts. People may just not have the same understanding of cultures, right? Uh, you see, in a lot of cultures, and this is what you call horizontal cultures versus vertical cultures. Asian society, right? I was born in Saudi Arabia, families of Indian origin. There is generally a hierarchy, and hierarchies are respected. Now, just imagine you're in a situation where you're asking a junior person to do something that may not be acceptable or may not be authorized by the senior person. You have to just be mindful of these realities. Now, I will just point one thing out, know when to draw the line. Sometimes people may tell you sexist things, may tell you racist things, which may really offend you. Those are things that I don't, when I'm told, don't talk to her, she's a secretary, that's offensive to me. And that is where I would draw the line. But beyond what you would consider to be a very serious violation of what is important to you, try to respect other cultures. Just know everyone doesn't do the things the same way. Everyone doesn't see things the same way, right? So keep this point. It is important. It is one of the things that I think sets a good lawyer apart from a great lawyer. Okay, this is just the final point. You are dealing with people, and people like to feel respected, heard, and valued. Michaela doesn't want to feel Kabir is looking at her as a taximeter. I'm going to keep billing, I'm going to keep billing. See, we're going to be doing that. But I want to be there for Michaela as a person. I want to know what are important moments in her life. I want to acknowledge festivals. I want to acknowledge holidays. I want to acknowledge tough moments if somebody falls sick in her family. I also want to deliver what I have told her. This gets back to where we started. If I tell Michaela I'm going to do this for $100 and give you the best service, do that. Your credibility is at stake. Uh, just, we're in a very tough profession. Let's not forget we're doing this because we like it. And let's try to make it a fun experience, right? If I go to London, catch up with your client for a coffee. Just meet them, talk to them, and you can talk about the case, but talk to them things not related to the case. What's your favorite meal? Where did you go? Just treat people like people. And I think people appreciate that because we like that, right? We like to be taken seriously. We like to be treated as people. I think I am exactly at the 20-minute mark on my clock. And that is perfect because I think, Michaela, with your permission, we can probably open it up for Q&A. And the Q&A, I think, we can keep it interactive. So Ilke, Svetlana, all of you will feel free to share your insights.
Thank you, Kabir. Indeed, you're perfect on time. No worries. We're happy to go a bit over the time allocated if you feel so. But I want to abuse my position as a moderator and ask one question, and then I will open for the rest. Most of the audience is form of junior lawyers, and I think will be important for them to know how can they train the skill of communicating with clients, how to make it from the person who's been copied or BCC in an email to be the one who sends or the one who receives an email. Maybe if you have some tips on that.
Correct. Look, when you're a junior, there are two suggestions that tend to be effective. The first tip is you want to get the opportunity. And one good way to get an opportunity to start building your skills is to do pro bono work, right? Go to your court, go to your local bar. Pro bono work is very satisfying. It helps you learn. For us in arbitration, do consumer cases, do small mediations. You get to deal with people one on one. It's very satisfying, but you also really get to hone your skills. So that is one thing, I think can be very effective. The second point, when you're in a law firm or in an institutional setup, volunteer. Go tell the senior associate, go tell the partner. Now, do it within reason. If there is a smaller case, ask, can I be the point of contact? Often partners like it when somebody volunteers to do the communication, when somebody volunteers to take what is often seen as grunt work. Volunteer to do that. Uh, Now, look, I don't want to be naive. Some firms are hierarchical, some firms are very structured. That's where pro bono comes into play. That's where you can try and do it. But if there is a smaller dispute, if there is a smaller case, those are often the best place to volunteer. When the stakes are high, partners tend to be a little more hoity-toity. uh, it's easier to do it when you say, look, this is an important matter. I know you're all busy. Would it be okay if I take this off your plate? I can put it in a way that makes them feel, Michaela wants to do the grunt work. Go for it, Michaela. I'll obviously keep you posted at all critical junctures. Be deferential, be cute. But that may be one way to try and do it.
Thank you. And maybe one thing I could add to that is
Please.
you can always update the clients on what's happening on the legal world that is of interest for the case. And one way that I used to do that, I will set up Google alerts with different keywords. I don't know, probably the most known one is the interaction between the intra-EU VITs and the enforcement of those VATs. So I will set up alerts for that. So I'll have updates immediately for the client. So that's a one tip on my side. But I will...
Fantastic. You're not stepping on anybody's toes. It's keeping you abreast of knowledge, and it's making you the voice of, the client thinks, oh, if there's a question, Mihaela is my person.
Exactly. And then the partners start to rely on you because they know you're going to be up to date with whatever's happening on that topic.
Mihaela, you raised a very good point. If I can just echo this, very often in a law firm, especially if you're very junior, you are told to think of your senior associate or the partner as a client, right? You may have no access. And that may be your tip is adding value to the partner, ergo your client at a very early stage. And that's one way to build your skills, both on the law and in diplomacy. So I really think that's a wonderful tip.
Let's now give the floor to our amazing audience, and happy to see some familiar faces. Let's start with a question from the chat. We have one from Arijit Sanyal. If you want to turn on your camera and ask a question, feel free to do so. If not, I can read it.
Hi. I'm still at work, so I would not be able to turn on my camera, but thank you. I'll ask my question. Hi, Professor. Hi, Ilka. Great to see you both. And yeah, my question comes from my experiences as a junior lawyer handling a client that has been stuck in a rather difficult situation. I can't disclose more, of course. What I wanted to ask was how to be empathetic of the client's issues, knowing well that what they are going through. Yeah. At the same time, how do you draw a line to let them know that what is acceptable and what's not acceptable, notwithstanding what's going at your end? I'll be really grateful if I can hear your thoughts on that.
Arjit, look, that's such a great question. And look, what is acceptable and what is unacceptable can honestly vary from person to person. I think there's some things we would all think are unacceptable. There are many things that can be gray lines. Now, there are two suggestions we can have. See, tip number one, it may be a little late in the situation you described, but at the beginning, when you're having the discussion with the clients, you kind of establish what the parameters of the game are. And if it is unacceptable relationships between you and me, the client and me, you can establish what is acceptable between the two of you. Look, for example, if you don't want to take emails on weekends, look, you can make that clear. Look, we typically do not answer things on weekend for reasons of mental health, unless there's something really urgent. We urge you to respect that. Just the expectation is set. Now, if something happens while the matter is happening and you feel it's really crossing a line, they're asking you to do something that is unacceptable, or they're saying things that are unacceptable, the first point, just give it a little bit of a break. Emotions can be high on the side of the client. Emotions can be high on your side, and both are valid, right? Both parties may feel, give it a little bit of a distance. That always helps. And then I just think, once tempers have cooled, once the passions have cooled, just, have a discussion on the issue. If you feel things have gotten so bad that you cannot speak directly one-on-one, get Ilka on the phone. Get a third party who's involved in the situation, get another colleague, and try to just have them mediate and try and smoothen the issue. Those are always tough. Arijit, I don't want to, we are in a, the fear is real that if I say something, you will go tomorrow to Svetlana. That is a reality and a risk. And, It's tough.
Yeah, thank you for that. That does help, and I think at times it's really better if you let things cool down and then take it ahead. Thank you so much.
Which is not our instinct. When someone
yeah,
says
of
something
course.
nasty, you want
I
to send
agree.
the email, go screw yourself.
Thank you, Arjit, for your question. We have another question from Rupali. So feel free to turn on your camera and ask the question.
Hi, Rupali.
Hi, hello. Thank you for the excellent presentation. So my question is that we are often encouraged to be a good listener, right?
Yeah.
But like where to actually draw the line? I mean, how much of a good listener do we need to be so that we don't end up wasting our time, or like perhaps not getting into the unnecessary details, like the emotions being flowing and like then it gets weird. And the second thing is like okay, yes, the regular feedback or like keeping the client updated on their case. So how much updates are actually sufficient, or like do they need to be involved too much? So basically, like where to draw the line? This is what I wish to know.
Rupali, see, that's such a great question and such a hard one too. Look, Rupali, how much do you want to deal with your client? Look, you want to allow them to feel heard. If you feel that it is, look, if it is a very, if it's a case involving employment discrimination, if it's a case involving destruction of business, emotions are going to be much higher and you want to give it the respect that it deserves. If it's a breach of contract case, clearly there are emotions. That's why a lawsuit is in front of us. But you know at a human level, right, that I don't need to treat this the same. I don't need to have the same empathy as I would for something that really objectively has an empathy. So I think make an assessment, I think it's a good idea to allow a person always to tell their story. Tell them, I'll give you half an hour. Tell me what happened. You can say the half an hour, 45 minutes. So you have already kind of established what you think is a reasonable benchmark. And I think, if people are getting into unnecessary details, and this happens, people are telling you details that, you hear them and are like, I don't know what you want me to do with that. You can just perhaps say, look, I think just in the interest of time, perhaps we focus on these 3 issues, or maybe give an agenda. Look, for today, we're going to talk about A, B, and C. It will require us to know, is Kabir the drama person here? It does require a little bit of assessment. Rupali, your second question was great. When should you tell Mihaela something interesting? And I think the answer there, I really liked it because it's something I didn't think of. You want to tell Mihaela something interesting when there's something interesting. Like genuinely. Mihaela is busy. She doesn't have the time. If you're sending her an email weekly, I don't think you have the time. Honestly, we are self-employed professionals. We bill by the hour. But when there's something significant, like Mihaela said, I'm looking at the EU cases. If it's a client dealing with EU cases, that is pivotal. So, within reason. Another thing, just send people Happy New Year, Happy Christmas, Merry Christmas, Happy Diwali. Those messages, those take less, but I think people feel acknowledged. If it's
Happy
people,
St. Patrick's Day.
yeah, Happy St. Patrick's Day. There you go. Exactly.
Very timely.
Yeah. That was a great question, Rupali. Thank you for
So much.
asking.
Great interacting with you. Thank you.
Thanks.
Thank you, Rupali. We have another question from ML, who I understand cannot address the question. Or
Sure.
can you? You can now. Okay.
She
No,
can't
she
talk.
can't.
She
But
can't talk.
okay.
She's in a silent zone.
I will ask the question. It's a very common one. What to answer to a client where you do not know the answer to that specific topic? When you're asked something that you're unfamiliar with,
Yeah.
and you don't want to sound incompetent, but then you don't want to say something wrong. So how do you strike that balance?
ML, great question. No, I'm going to tell you something that probably as a junior lawyer will surprise you. Nobody expects you to know everything. Truly. And if it's something you should know, just tell them. it's a partner, it's an associate. Let me get back to you. I think I know the answer. I want to check and verify, and I'll get back to you. Say that. There's no shame in that. Nobody expects you to know everything. You're much better off saying, I'll get back to you. And if you think it's really urgent, I'll get back to you in an hour, and then really scram in that 1 hour and do all the readings you can. And you can always tell people, look, my preliminary research tells me this. If it was something very urgent, I'm happy to look into it in further details and add your caveats. But don't hesitate to do that. If it's something that's really obscure, somebody's asking you, I know a decision came out from the English Commercial Court on Monday or Friday. Can you update me on that? Just tell them, look, it's a recent decision. I want to read it. I know the decision is out, but I'll get back to you by Friday. I would just urge you. I think that would be, don't put the pressure on yourself for being somebody who knows everything or is expected to know everything. That is just not our job. If it was something people could figure out by Professor Google, trust but verify even Professor Google, they wouldn't come to you. Right? So that would be my suggestion to you. Just be honest. I'll look into it. I'll get back to you soon. If it is uncomfortable saying I don't want to, it's not a good feeling to say I don't know, and just say I'll get back to you in an hour. Good, great. Thanks so much.
Thank you, Amal. We have a question from Sveta. Please go ahead.
Thank you.
It's a hard question, but ask it.
Kabir, thank you very much for the excellent and insightful presentation. So the question is whether you've encountered any situations where miscommunication led to a misunderstanding or even a conflict with the client, and how was that resolved in the end?
Have there been miscommunications and misunderstandings? I think the answer to that is yes. I think that is inevitable in our life and in our profession. Just because you tell people something, but you don't tell them, oh, this has happened, that has happened. Just an instance was, everything got moved by 2 weeks. And that, in a very busy period when the rejoinder was being drafted, didn't get communicated to the client. And obviously the client was moving on a very different schedule, and they were like, where is the rejoinder? Why have you not received the rejoinder? And this was awkward, it was embarrassing, but just again, this is one of those situations, Svetlana, just own up to it. Screwed up, sorry, we'll do better. Then you catch somebody in your team and scream, I'm kidding, don't do that. A screw up is a screw up across the board. So never find somebody to blame. I feel that's never a good thing. We can always discuss how we avoid those situations. And this is having a point of contact best practice. But establish that. Now, Svetlana, you can have more serious miscommunications. Your client is taken off surprise. I think the situations where the most severe misunderstandings arises, something totally unexpected happens. And I just think at every stage you want to tell people best and worst case situations. If you're dealing with a state client, they don't want to give documents from different agencies for national security reasons. You really want to advise that the tribunal has ordered you to produce them. There will be very serious consequences if you don't. And look, we will do what you advise you, but we really strongly advise you to produce and, make the appropriate arguments. Then don't produce. If you don't, this is the real risk. Adverse inferences, adverse cost order, you're losing your credibility. It makes it look mafioso.
Definitely, you should not tell them to take care of the documents.
Yeah.
That's what we learned today. I'm mindful of the time.
Either of y'all,
Please.
do y'all have any tips for that? I really think this misunderstandings is really real. And I just wanted to see if any one of you had anything to share.
Well, I just recently had a misunderstanding, though not with a client, but with a colleague. On that line, for sure, it's probably a bit easier. But my approach in general with communication is communicate. So speak to try to actually address it. For sure, it's a question on when and how to do it, in particular with a client, even more than with a colleague. But in order to be able to solve a conflict and a misunderstanding, it has to be addressed.
Yeah. Things fester. They become bigger and bigger and bigger. So I think,
Exactly.
Thank you, Kabir. Just one more point maybe on that, just to remember the clients, as any other people, have different personalities, and some might be more receptive than others to any sort of misunderstandings in communications, and that's just the way it is. And we can control and mitigate some of these issues, but ultimately every client is different.
Svetlana, I think just to underscore that point, I think it flows beautifully from what you said, and it's relevant to Ilka. At certain stage, you have to realize that I can't be best friends with everybody. I've done what makes sense for me. This is just, we have to get to a stage we can work together and be professional, but with the client, don't tell it to them. But with your colleague, look, I've made peace with the fact we will have a workable relationship, respectful, but it ends at that. I mean, I think that's okay. We want to have a good relationship. Humans like, I don't think we by nature like confrontation or conflict, but I'm going to get along better with X than with Y just because I have more in common with X, our values match, than with Y, and that's okay. I don't have to hate Y or wish that Y burns in hell, but hopefully Y and I can come to a level of understanding that we can proceed, and that's okay. I really love that point, so thank you for that.
Thank you, Kabir. I know we have reached the mark of our allocated time. We have someone who said we're going to have a comment. So Vivian, if you can turn on your camera.
Yeah.
Try again.
Yeah, thanks very much. I'm not going to put on my camera again because I'm back at work, but I just want a quick comment. First of all, thank you so much, Professor Kabir, and to Lauren Plus. You all have been so marvelous. This is a very relevant and topical topic. My comment, which I wanted to add, is that I'm coming from in-house. I'm an in-house solicitor advocate. And sometimes getting instructions from clients is usually extremely, well, it's challenging. So what I have learned over the years is I befriend them. When I say I befriend them, I don't mean I take them to lunch or go for coffee, but I do small talks with them, and then they relax and they're able to, engage with me properly, to give me the instructions I have to proceed the case. So I find that befriending, i.e. not being too formal with clients, produces excellent results. I know we are running out of time and I'm not going to take much of your time. I thought I should share this for those that are, junior lawyers, that it's actually excellent to actually get to know your clients. Talk about travel, talk about weather, talk about, oh, you have a granddaughter, what school and stuff. It does actually help.
That was fantastic, Vivian. While you were talking, and thank you so much for sharing that. I remember the story, a lawyer showed up in Silicon Valley dressed up in a suit with a tie, the way one envisions a lawyer showing up. And actually, everyone at Silicon Valley looked at him and said, no, we want you to be in shorts and T-shirts. And he was like, no, that's not how we conduct ourselves. But the client was like, no, you're making us all uncomfortable. This is not us. And I think your point, doing what makes people comfortable, trying to take some of the stress and, this is going to be a litigation. It's so, thank you for sharing that. It's so on point.
I think that's an excellent way to draw to a close, and to thank our fantastic speaker for being with us today and for sharing these amazing tips. I want to thank the audience for tuning in today, and to let you know that we're going to have a next session with on the 21st of May, and we're going to discuss about communication inside the law firm. So how to manage conflict inside the law firm and how to communicate with your peers and so on. And we're going to make the session available on our YouTube channel, and also going to publish a summary on Youth Connect. So hope to see you next time, and thank you again for being here. Have a lovely day.
Thanks, everybody. Bye.
Bye-bye.